This is a true crime discussions channel. We speculate. This is all just speculation. Because it's true crime, it's for mature audiences only. There will be no children allowed, no exceptions. Everything on this channel falls under fair use. Please remember to like, comment, subscribe, and share. It's free.
Hey y'all, thank you for being here. Monica said the intro song sounds like you, and I've heard that, believe it or not. Thank you for the compliment. I think that it's by Mike Stringer. It's called Pull Me Out, and I think that the singer has a very beautiful voice. So that's a compliment for me, and I really appreciate it. I want to let y'all know real quick that the sheriff that shot the judge is having a preliminary hearing, so we might jump over there real quick first. Also, I just found a video titled "AustinDrummond's attorney speaks to the press." So we're probably going to, like normal, go over some things that aren't even in the thumbnail. Do y'all want to see the sheriff who shot the judge, the preliminary hearing? That's out of Kentucky. He walked into the judge's chambers and just shot the shit out of the judge. Was freaking out and paranoid afterwards, saying that they were trying to kill his wife and daughter. And rumor had it the daughter might have been studying under the judge, so there might have been some kind of sexual relationship going on. They had a brothel in the courthouse. It's a whole thing. Let me say hey to y'all. Miss Scorpio Rising says yes, thank you. Ava says yes. Lori, good to see you. Good to see y'all. Teresa, good to see you. Oh my goodness, I'm sorry, Teresa. That's awful. Kimmy C123, good to see you. Abellis, good to see you. Southern Cats. AM, good to see you. Michelle, good to see you. Stephanie, good to see you. Snarky Pants, good to see you. Becky P, I saw that you came in. Miss King of Anything, good to see you. I know, it's really sad. And that song I have is even sadder. I'll have to do one that's not quite as sad next time. Lorianne, good to see you. Abellis, my love. Michelle, Southern Cats. I saw Wolfpack, good to see you. Heathen, good to see you. Um, and I saw Kane's Nana came in earlier. It's good to see you. Everybody, good to see you. Kathleen, good to see you. Scrolling. Sandra, good to see you. Love to love, good to see you. Hannah UK, good to see you. Rubber Ramada, Cindy from sunny South Florida. It's good to see y'all. Let's scroll back down. Oh my goodness. Thank you, Miss Scorpio, for gifting a membership. That was so very sweet and supportive of you, and I really appreciate that. I don't know who it went to as I have not accessed my live yet, but if you were gifted from Miss Scorpio, please tell Miss Scorpio thank you. I went to Gertie. Gertie, Gerti, Gertie, if you're here, please tell Miss Scorpio thank you, and I will grab the crazy train to pick you up on the way to Speculation Station. Thank you so much, Miss Scorpio. Thank you so very much for that. Soups, good to see you. Okay, so we will jump right into the preliminary hearing that is going on right now. I'm going to speed it up a little bit so that we can get through it a little bit quicker and maybe catch up to where they're actually live. I don't know, but we're going to watch it. Maybe. There it is. I wanted to see, I think that's his daughter right there, maybe, or his wife. Okay, we're going to go to where they're in court. That's his lawyer. Yes, thank God it's Friday. Okay, he's not there yet. So it's all waiting for him to arrive. There he comes in the courtroom. Hey, Orange Rose. All right, he sat down. He looks worried. Good gracious. I think the judge is just about to come in.
All right.
Yep, there they are.
Honorable Christopher Golan presiding. Please be seated and let the court come to order.
All right. Yes, Amber. Yes.
This is 24 CL 204. Public technical facility Stines.
Good to see you.
Special judge appointed in this matter. Public to identify themselves and their counsel.
Jackie still got phone, but.
Brings it out on behalf of the common. Trevor, here's what we will have to show.
Deputy Your Honor, Jerry Barley on behalf of the district.
All right, thank you. See Mr. Stines is present. The court set this matter today for the status hearing to address a few matters. I think we're in such a position now where we will be able to set some upcoming court dates to get this matter proceeding forward. We have been waiting on a KCPC evaluation to be done on the defendant that has been completed. It is currently under seal. As procedure is done standard in any type of case such as this.
Okay.
Right now is under seal.
So he had the mental evaluation done and it's under seal. This is supposed to be the preliminary hearing.
There's been a motion for the KCPC evaluation to be unsealed. Mr. Barley, that's the main purpose for that, as you wish to, if the court does that, and then the hearing and the other two motions, you wish to have that as potentially used.
That's correct, Your Honor. Our intention.
Okay, he's looking around like he's crazy again. Remember when he got arrested, he was like, "What are you doing? Don't take me here. Don't take me here. Don't do this, guys. Don't do this, guys." I know I can't hear it either. It's very hard to hear, and I'm trying to tell you guys what I'm hearing. Hopefully they'll fix it. Good to see you, Trees. I'm trying to be quiet, and then I'm gonna let it play, but I'm gonna try to pause it and tell you what it says. I've got closed captions on, but I don't know how to if unless they're gonna fix it. I'll turn it up, and you can see if you can hear it better, but I don't know. I'm gonna try to tell y'all what I hear.
To have it for the purpose of those evidentiary hearings, I believe that it contains, without speaking about what it contains specifically, Judge, I believe that it does contain valuable information that the court would be able to use, particularly in the bond hearing in terms of coming to, making the court's findings that are necessary to determine whether Mr. Stines is a good candidate for a bond in this case. And so I think as it pertains to the motion to dismiss, Judge, there's also some information in there that will go directly to some of the testimony that was given at grand jury.
All right, and Mr. Steele, how long, you all don't have a response to that, in the notes that, how long do you all have?
Judge, you give us 10 days. I think we got it last week, so if you give us 10 days to respond to that motion. Thank you.
All right, what I would like to do though is at least see how far we can get without addressing the Dixon PC evaluation issue. And the fact, so the court has read that, so keeping that in mind.
They're talking about the mental evaluation. They're saying about going over it for a bond hearing. She said that there's important information in the mental evaluation that they need to talk about. And he's right now talking about PC, which I'm going to think is protective custody. He's looking around like he's lost his mind. In my opinion, like Miss Scorpio said, there was stuff that he knew going on. He wasn't just paranoid, and he's not just paranoid, in my opinion. That town had a lot of backdoor things going on, considering that the damn judge's chambers was a damn brothel. Hey, Vicky the Leo and Psychic Amelia. Good to see y'all. Yeah, corruption. It was like corruption on top of corruption. I I don't know, man. I don't know if he's playing or not. Like not playing, but putting up a front. All right, I'm gonna keep trying to tell y'all what they're saying, what I hear.
We can address first, motion to dismiss the indictment.
Your Honor, I will.
So right now they're going to talk about a motion to dismiss the indictment.
We filed a motion to dismiss on 2 grounds. Number one, under RCR 5.16, failure to provide or to add a transcript of the grand jury proceedings. Court knows RCR 5.16 requires that any testimony taken from the grand jury must in fact be recorded. Now, we kind of came upon that surreptitiously. We were listening to listening to the grand jury tape, and there was a reference. Your Honor, I don't know if the court has made that grand jury, can I speak to the content of the grand jury and decide for what I think?
Yeah, and for first record, the court has provided a transcript, CD recording of that we used for.
Thank you, Your Honor. So there's a reference to one of the grand jurors that said, in our last meeting, or in our previous meeting, and I'm paraphrasing it. And so at that point, we weren't aware of the previous grand jury hearing.
Okay, so they're talking about transcripts, and they're referencing transcripts, I think, from a different case or some kind of transcripts. And in the transcripts, somebody references a previous meeting. They weren't aware of a previous meeting. So basically, somebody held a meeting that they weren't supposed to hold off the record, is what it sounds like so far to me.
So I inquired on they did respond to it. The response was basically, well, we met with them. The purpose was just to get a subpoena for medical records. And the judge anticipated a response. But I guess, one, what's odd about that to me is 100,000 grand jury hearings, and if you want evidence brought to a grand jury, it's usually submitted back to the hearing. I mean, there's no reason not having permission for the grand jury to subpoena. You send a subpoena, you subpoena the custodian to the hearing.
So basically, the excuse was that they needed some kind of medical records, and their response was, "Oh, we just needed medical records, so we got that," and they didn't subpoena it through the court, which is not normal. And I think it's important because when you're talking about a case like this where there was so much corruption and backdoor dealings going on allegedly, it's important when you've got people meeting in private because again, the judge was meeting in private with inmates at the jail, and who knows who else. And so was the deputy that ran the drug program that put the ankle monitors on, and they were having sex in the office. They were basically abusing these female inmates in exchange for money for their drug program ban. So when you're having meetings off the record, yeah, it's a bit suspicious.
And then the second piece of that concerns me is that even if we presume that is what was going on, and I don't know, there's no recording, but if we presume that's what's going on, unless there was some sort of, telepathic thing going on, there had to be statements made to the grand jury that said, hey, this is this case, this is what we know, and I think the Commonwealth was making the distinction that, well, if you don't come in and raise your right hand and swear, it's not testimony. Well, actually, the distinction is sworn testimony or sworn testimony. I'd submit to you that the only way that you're asking for a subpoena and you're basing that on some sort of probable cause or evidentiary standard that you want the grand jury to consider, which is the only thing that makes sense. You have to tell them something. They didn't walk into the grand jury room and say, just look at each other, and the grand jury says, hey, we'd like to correct this thing. Now, I will say this.
Basically, there was some kind of conversation that took place where they would want medical records subpoenaed the grand jury. He's saying basically you don't just walk into the grand jury room and they telepathically know that you need medical records. Like something was said. Now, from my understanding, he's saying basically we don't know what was said because it wasn't done in court in front of everybody. It was some kind of backdoor meeting. And so that's kind of what he's bringing up. Hey, everybody coming in. While you mow, you be careful out there mowing, Zan. I've been outside cutting weeds myself.
Talking about their legal advice to the grand jury, and the grand jury deliberations do not have to be transcribed. But whatever was said to the grand jury, if you to ask for or form their basis for asking for medical records, Judge, I think that should have been recorded, so we would have that available. And I think 5.6 requires it, and the remedy is that going shall form a motion to dismiss.
So he's trying to get it dismissed on those grounds because the grand jury meeting was not recorded, which under code is supposed to be.
I can address the other area, Judge. Okay.
I think this is the second reason they filed a motion to dismiss.
Second area, Judge, I really think Kendra, that may need an evidentiary hearing. It may not. I mean, I'm not sure.
He's saying the second reason to dismiss may need an evidentiary hearing, but he's not sure.
I'll leave that to the Commonwealth as the response to that. But in terms of the other portion,
statements made something, I couldn't catch the end of it.
As to the second portion of my motion, it's based upon Commonwealth feedback, and Mr. Cox actually handled Mr. Baker in that case. We all know the prosecutor's community is the aluminum back case. Detective goes in and testifies and says, basically it was aluminum bat used, this one used aluminum bat. In reality, it was
Okay, so the detective came in and said somebody used an aluminum bat.
wooden stick or something.
And in reality, it was a wooden stick.
And in that case, following conviction and appeal based upon that testimony being misleading.
Okay, I'm assuming it was a different case because he's saying in that appeal, so that was a different case that's already been to court, been tried, and they appealed it on the grounds of that misinformation of the detective saying that an aluminum bat was used in some kind of case involving somebody else. And in reality, it was a wooden stick that was used, not an aluminum bat. And an appeal was filed, and they're talking about that case specifically.
The Supreme Court stepped back and said, look, if you give evidence to a grand jury, you get misleading.
And then the people sent it back and said, look, if you give evidence to a grand jury, you can't mislead them like that. So they referenced some other case talking about the second reason why they want to dismiss.
And this, and the bigger debate really seems to be after that. This arises to prosecutorial misconduct, which should stand with prejudice, or is it not? And to me, that
And he's relating it to prosecutorial misconduct.
falls into the without you representing the grand jury. And so when I look at the grand jury transcript, Judge, and without getting into the case of the Eastern report, one of the big things that bothered me was the grand jurors. First of all, they spent nearly half the time asking questions, and a large portion of those questions concerned the mental health of Mr. Stines. And the last question before the grand jury retires from deliberation was, so he was in the same mind as far as the investigation is young, and the answer is yes. That's Detective Stanford testifying. Now, first of all, probably not an appropriate thing for Mr. Stanford, Detective Stanford, to give an opinion on, but the rules of evidence, I get it. I mean, if there's an evidentiary issue, that's not what we're talking about.
Okay, so the detective said he was of sound mind before the grand jury retired, and he shouldn't have done that because obviously, I'm assuming where he's going to go with it is that the detective is not a psychologist, so he can't say that somebody's of sound mind or not. But he's saying, I get it. If we're talking about evidentiary hearings and things, that's what I've got so far.
If you're going to let a detective testify about sanity and rendering opinion,
Right.
that grand jury takes that to heart. He's seen all these facts, and I submit to you, without getting, I can't reference the report, but I'll say this. You're hard pressed to find much in the way of investigation that would support the adverse. And so, this is what I believe. I believe that had they not been told by a prosecutorial stamped witness, someone from the government, that he was sane, they wouldn't have died this case. Or at least they might not have indicted on murder.
Okay, so basically what all that was to say was that if the detective had not said that he was of sound mind, or basically somebody from the government saying that Mickey Stines was of sound mind, he doesn't think they would have indicted Mickey Stines in this case. Because obviously, or the way they're going to present it is that Mickey Stines was obviously not of sound mind.
And so, what I think, Judge, is that even if the court did find that this arises to a level where this case should be dismissed with prejudice, which is what we would ask, at the very least, I think this thing should be remanded back and sent back to the grand jury and let them hear the correct evidence. If that statement would be corrected, or at least take it out. I mean,
They want to dismiss it with prejudice, but if they can't, they're saying they want to kick it back to the grand jury and let them hear it again, or at least take the statement out where the detective says that Mickey Stines was of sound mind.
I don't think they have to put on evidence that's exculpatory for us. And I don't think that, it's a, they can let somebody opine to what an expert would say, even if it's a layperson. But if you do that, it can't be wrong. That's a pretty risky thing. And here, the investigation, it definitely didn't show anything the same. And there's other additional issues, Judge, and that's one of the things we want to have the evidentiary hearing for, is to ask about all these statements and what the detective had in terms of the investigation. We want to put that on the court to show why we believe that that was missing, in addition to anything else.
They want to present. Hold on.
And what the detective had in terms of the investigation. We want to put that on the court to show why we believe that that was missing, in addition to anything else.
They want to show why what the detective said and any evidentiary information was misleading, along with anything else.
And if you would agree, you require that faith.
Yeah, I mean, Judge, I think that in the non-Baker case, they said it was reckless. I mean, because basically, and I think it's, and I do think it's at least reckless. But I think we need to hear more about what detectives think or knew. What he knows now doesn't matter. I get that, it's irrelevant, right? But what he knew the day he testified is very relevant. And I can think of one witness, an attorney, who specifically said, I think he's had a psychotic break. And so to say that your investigation so far is showing us in the same mind, yes, I think there's at least enough there, Judge, for let me put the witness up there and ask him. And then, Your Honor.
So when we watched the detective who had just taken over the case testify in this case and say that he was of sound mind, after even in the evidentiary hearing where they put the video on the screen and they showed like the 30-second clip of where he walked into the judge's chambers and just shot the shit out of the judge. There was even people that had testified there, evidently, who said that he was not, that they thought that he had a psychotic break or that he was not of sound mind. And then for the detective who had just taken over the case to say they believe he was of sound mind, they're basically trying to get it thrown out on those grounds, or at least kicked back to the grand jury to go over again.
There are additional items that I think are also of concern. There's a question. Outside of those, Judge, and those are additional items. If the court doesn't want me to go about each instance, I'll just say that is the sort of thing that I think we need to know from Detective Stanford. If you knew these things, why did you answer this misleading way? And I think it's reckless at best. And
all right, hold on, because I know a lot of y'all are asking. Look, this might remind you. The video right here. He's got the gun at the judge. And he's walking behind the table and he shoots him one more time. Y'all remember that? This was the hearing they're talking about right now.
Okay, is that a portion of the video? Yes.
And that wasn't even the worst of it. Like that was when they had the 30-second video out. It got there was a lot more to that video, but it showed him shooting him a total of, I think, 9 times. Yeah, the judge was smoking a cigarette in chambers, and that was one thing we pointed out as being suspicious because that's not usually allowed anymore.
Unless the court wants to certainly take an interest in the issue and dismiss without an evidentiary hearing, we would request that as well, Judge, but if not, we would ask you to put on. Please.
Thank you, Your Honor. Your Honor, the Commonwealth is of the position that we certainly acted in compliance with the rules of criminal procedure here, the rules specifically that were cited by defense counsel. We would ask that if the court to dismiss the motion, to deny the motion to dismiss the indictment as it's wholly without merit. Your Honor, here, counsel is correct in citing Rule 5.06 that we could have unilaterally issued a grand jury subpoena to obtain these mental health records. That is a power that the Commonwealth does have. However, in taking an extra step in the interest of transparency, as the grand jury is an independent investigative body, and to ensure that there was no argument that we were usurping our grand jury subpoena power, we appeared before the grand jury on October 17th of 2024 without a witness, specifically to ask for these mental health records from two different providers for the defendant. We appeared at that time, there was no witness, there was no testimony presented. Counsel, again, is correct that pursuant to Rule 5.16, had testimony been presented at that time, it should have been recorded and would have been required to be recorded. Myself and Mr. Steele. Only the special prosecutors were present. No witnesses appeared on behalf of the Commonwealth. And so, Your Honor, the rule is clear. It requires testimony in order for there to be a requirement for recording. And there was no testimony presented at this time. And I think that is apparent. The court now has a copy of the actual recording of the grand jury proceeding for the testimony that was presented on November 21st, the only time that testimony was presented. And I believe a review of that testimony, some of which is referenced in the Commonwealth's response that has been filed, will show, based upon the questions that were lodged by the grand jurors, the only thing that was requested at that time were this grand jury subpoenas for those medical records. I think that's reflected in the context of the recording of the grand jury presentation. I'm sorry, Your Honor.
You as actually court representing that until the request made?
Yes, Your Honor.
There's no verifiable commentary or anything?
No, Your Honor. Specifically request for those grand jury records, for the mental health records pertaining to the defendant, one from ARH and one for Leslie County Detention Center.
Just a point of clarification, if I understand your question. As you can imagine, nobody in the grand jury room needed to be told what case this was, or anything regarding the facts. So when we went in and we said, we're the special prosecutors in this case, we're here just so we can get a grand jury subpoena for mental health records. They began asking questions, of which we did not have an answer to.
Well, I mean, it would have been a lot easier, though, if you just recorded it like you were damn supposed to. I mean, again, when we're talking about this case and all the corruption that was involved in the shit, why not just record it for safety? Like, what the hell's wrong with you, sir, that's about to fly away with them damn ears?
Never answered any subsequent questions other than that. That's something we're looking at. That's part of the investigation. Those matters get presented to you. There was never, of course, at this point in time, the preliminary hearing argument had, the video was already out. Other videos had been released. There was nothing we added at all to any conversation regarding the case other than the investigation and why we need the records. That would be it.
And Your Honor, additionally, we asked the grand jury to memorialize what was being requested as far as the grand jury subpoenas in writing, which was authored by one of the members of the grand jury and signed off on by the foreperson. The verbiage of that is reflected in the response as well, but specifically which records they were requesting and authorizing via grand jury subpoena. So those grand jury subpoenas were issued, the records were received, those records were then promptly provided to counsel for the defendant on December 4th of 2024 in the very first discovery packet. So in compliance with our discovery obligations, Your Honor. So
basically, they're saying that they have the records, but it's transcripts. It's not a recording, which it should have been. Especially, again, when we're talking about Kentucky and all of the corruption.
Commonwealth believes it's clear, based upon the rules of criminal procedure, that we acted in compliance with those rules. We have additional arguments as far as the Jackson case. However, the Commonwealth does not feel it's necessary to delve into those at this time unless the court would like to hear them as they're reflected in the response. All right, thank you, Your Honor. So clearly, we do not believe any evidentiary hearing is required with respect to the argument that there was no recording made. That is apparent from the recording that the court already has, so no evidentiary hearing is required. As far as the second argument, turning to the actual content of what transpired and what Detective Stanford testified to and the questions that were asked during his testimony to the grand jury in November. Your Honor, I think defense counsel is conflating the role of a grand jury proceeding with the role of a criminal trial. It is very clear under the law that they are distinctly different proceedings. The grand jury is an investigative body. The Commonwealth has no obligation, as reflected in an abundance of case law, to come in, to present exculpatory evidence, and to attempt to mount a defense for the defendant. That is not the Commonwealth's obligation. Additionally, the rules of evidence, particularly Rule 1101, does not says that the rules of evidence do not apply to grand jury proceedings. So, hearsay, opinion testimony, the right to remain silent, all of those things are not required to be adhered to at a grand jury proceeding. If they were, our grand jury proceedings would be the same length as a criminal trial. It's not tenable. Exactly, Your Honor. And so I believe counsel's arguments are confusing the two, the purposes of the two. You know, hearsay is presented routinely in grand jury. Opinion testimony, such as Detective Stanford's testimony, is presented routinely at grand jury. These are commonplace and they are permitted under the law.
I haven't been saying anything because I know that y'all can hear this, so I didn't feel it, the need to tell you what they're saying. It's not as hard to hear as Mickey Stein's defense team.
Absolutely, Your Honor. Certainly. And, Your Honor, the Commonwealth is of the position that an evidentiary hearing is not required. Everything that transpired when testimony was presented to the grand jury in November is captured on that grand jury report. The Commonwealth cannot conceive of a reason to haul witnesses in to talk about what transpired because it's on that recording, Your Honor. And so we do not believe that evidentiary hearing is required. Or is required, sorry, Your Honor. So, Your Honor, again, the court has that grand jury recording. We would ask that it be filed under seal as it was a grand jury proceeding. And we would ask the court to deny the defendant's motion to dismiss the indictment in its entirety without any necessity of an evidentiary hearing. And we would rely on our pleadings submitted as well, Your Honor.
Just briefly reply. Yeah, Judge, so I mean, I didn't put anything. I said, leading judge. I understand we're talking about rules of evidence. The reason I cited to the issues where there were things that normally wouldn't come in is because there were instances throughout the grand jury when the witness was about to answer something the grand jury asked for and it was shut down. I was contrasting. Oh, I get that, Judge, but my point is this. If you put that into context with what they let testify, then I think ultimately, Judge, put on that evidence will show you that this grand jury is misled. I mean, the state alone, to be honest with you, the state alone of rendering opinion on standing is, in terms of, I get you don't have to be an expert, Judge, but if you say it, you can't miss it. And then, so I'm not asking the court to look at whether things should have been admissible or not. I'm not at all. My point is that the grand jury is an investigative body, and they don't get to dictate what they hear if the grand jury is asking for additional stuff. So in other words, if they ask a question and it's germane, I'm talking about relevance, it's germane, it's their grand jury. It's not common courtesy. They're the investigative body. And so the reason I cited to the things that I thought should have came in is that it contrasts with other things that I think they asked and never got told because the questions were replayed. And that's why we're asking for the.
I should have talked about 20,000 basis being presented for a grand jury.
Sure.
In Your Honor, if the Commonwealth may, thank you. I would like to make a distinction. The Baker case, we're talking about misleading to the extent of an aluminum bat versus a wooden stick. I don't think there's nothing even alleged in the pleading, even if you take everything in the pleading that's been said today by the defense as true, that would be tantamount or even close to that, Your Honor.
So basically, what she's saying right there is that it's the Baker case they're talking about, where the detective said that he was using an aluminum bat and he was actually using a wooden stick. And what she's saying is, if everything the defense is saying is true, even like as far as the detective saying that he was of sound mind, even though people were also saying that they thought he had a psychotic break, it doesn't amount to basically the gravity of what I'm going to assume to be a murder weapon or deadly assault weapon, the aluminum bat versus the wooden stick. We're not looking at something as paramount as that in this case, where you're talking about sound mind versus not sound mind. But I disagree, because that's going to be the basis of this whole case. He appeared to have a psychotic break. I don't know that he did. I think he's playing it off, but that's my thought on that. And he's saying he's got a bunch of cases. There's 10,000 grand jury cases. He will review it. And she asked to speak again, and that's what she said so far, about referencing that it's not as paramount as saying there was an aluminum bat used when there was a wooden stick, referencing the detective saying that he was of sound mind versus somebody saying he had a psychotic break.
You know, as far as the mental state of the defendant at the time of the offense,
Hey, Mike.
that wasn't even an issue
Blue
at
Jay.
the juncture of the grand jury. That hasn't been raised since by defense counsel. So, Your Honor, again, I don't believe that those arguments are well taken. We would ask that you deny their motion to dismiss in its entirety.
I'll be more, well, if I need to hold on to it, if not, hopefully we
Yes, sir.
Next, we'll go to Brian.
Yes, Your Honor. Again, Carrie Wortley for Sean Stines, Judge. And we filed our motion for the court to, it's been back quite a ways now that we filed that, but we did ask the court to kind of hold off.
I think pursuant to criminal rule 440,
Thank
I
God.
believe it is, we're entitled to an evidentiary hearing. I think it's going to be necessary for us to bring witnesses. We have some witnesses lined up. And I think it would be necessary for the court to hear that evidence and make its findings on whether there are several factors by statute that the court has to consider when determining whether bond is appropriate. And there's an added level here, and I anticipate the Commonwealth will argue that Mr. Stines is not entitled to bond because of the way that this case is charged. Okay, so in that.
Sorry, I am here. I just was being quiet for the most part so we could listen. I looked in the back, Cat, in the beginning, and it looked like his daughter might have been there in the back, but I couldn't tell. Online, a couple of creators are extremely sympathetic to Mickey. Really? Hey, Native Girl, and everybody coming in.
That situation, Judge, they're going to have to put on proof. It's actually their burden to show the court if that is in fact what they argue, and I don't know, I'm just anticipating, but it is their burden if they're trying to preclude him from bond at all to put on proof that guilt is evident, or the proof is essentially, there's great evidence of the proof, right? And so I can anticipate what those arguments are going to be. I can anticipate all of that, Judge. But I think, given what we know, and again, without putting any of that on the record today, given what we know now, I think we'll have a heck of an argument on bond.
What would be your proposed bond, in light of the circumstances?
Absolutely. And given what his income is, given what he's able to post, and I think that's what the statute requires the court to look at, is what he could reasonably post. We would propose.
Public safety is a factor also.
Absolutely. There are several factors, Judge. I just think that in terms of what the amount would be, the court has to look at what he could reasonably post if he is in fact entitled to a bond. So
right there, I think that's his wife in the yellow and his daughter right there in the gray. And we can hear a lot better, so I'm going to be quiet and listen. But if I feel like I need to break something down, I will. Obviously, right now they're talking about bond. Those of you coming in, this is the case of Sheriff Mickey Stines, who walked into the judge's chambers and shot Judge Mulliens 9 times. There was allegations of a brothel going on. They had just went to court about that a week earlier. The guy running the drug program who had the ankle monitors was basically getting sexual favors from inmates to pay for the ankle monitors. And then the sheriff's daughter was allegedly studying to be a judge under Judge Mullen, and he was having sex with people in his chambers after hours too. It's a whole bunch of corruption and craziness. Allegedly, the night before the homicide occurred, Sheriff Stines had been kicked out of his house by his wife, and that's why he was wearing the same clothes or some shit from the day before, because he hadn't been home, he hadn't slept all night, and he walks into the judge's chambers and shoots him and says they're trying to kidnap my wife and daughter.
Our proposal, Judge, would be 50,000 cash for property with any non-financial conditions that the court would require, and the court could set a host of non-financial conditions, Judge, as you well know. However, I think that given Mr. Stines, and again, without waiving any of our, any of our ability to put on proof, I would ask the court to take a look at the fact that he is, the lowest possible risk level that one human can be. In terms of his pretrial
pretrial risk assessment, with all candor to all parties, is something that, as a prosecutor, now as a judge, I don't have the utmost faith in.
I understand, Your Honor, but it is also something that the statutes require the court to take a look at, and there has to be some other evidence that the Commonwealth can put on, or some other evidence in front of the court that he would be a flight risk, that he would not return to court, that he would be a danger to himself and the community. And again, I think that's why it's important for us to be able to put on proof and to be able to put on some of the stuff that's in that basic piece to the court. I think that when we are able to show the court what's in there versus, all the other things, I just don't think there's anything to show that he's a flight risk. There's nothing to convince the court that he would be a danger to himself or others. And I understand why we're here, Judge, and I get that. But the courts have said consistently, and it's, I believe, the Abraham case, that you have to look at something other than the charge.
I
It has to be
understand.
something else, right? We can't just look at the charge defense.
But that can be factored in.
Absolutely. So, Judge, I think we're going to need that testimony and we're going to need that report. I would ask the court, again, without waiving anything, I would ask the court to consider setting a bond. The court, of course, can do that at any time. And that would be our requested bond, 50,000 cash or property. If the court wants to hear just a little bit about what we would put on.
So they're trying to be able to bond him out, and he's requesting. They're saying a bond of 50,000 would be good. I do believe this is the judge's wife right here, and this is some family members of the judge over here. Judge Mulliens, who's now dead. This whole side is full, and there's barely anybody on this side. The whole town came together in this instance, and it's just a bunch of mess.
Again, Mr. Stines is a member of this community for his entire life, born and raised here. He has a great deal of family support through all of this, as the court can see. He has a wife and daughter that he can still go home to today. He was a member of law enforcement for basically his entire adult life, up until the point of his arrest. Is a respected member of law enforcement, a respected member of the community, and frankly, Judge, everything we've learned about him since then corroborates that. And I would have testimony to that effect. There's no evidence that he would be a flight risk. Nothing. He has no failure to appear on his record. He has no, property in the Bahamas that he can run off to. There's nothing. This is a man with a great respect for the law, and he's built his life around upholding the law and serving his community. Just there's nothing that I've seen that anyone's seen. And frankly, what we put on our proof of the court will see, there's nothing to say that he would not return to court. There's nothing to say that he would commit another offense. There's nothing to say that everything in this pretrial services report, respectfully to the court, is not correct. That he's a low 0-0 risk, Judge, because this is a man who, again, there's, with all due respect to the court and to everything that, you know, for the reason why we're here, the court does have to look at something other than the offense charged. I know it's a good one.
I understand that, but this, you would have to admit, is a unique fact circumstance.
Absolutely.
This is not a whodunit. I mean, the actions are very evident. What the end result of that is, that's the purpose of the case as we're proceeding.
Yeah.
So, all right, I understand your argument.
I mean, okay, if we're going to talk about him bailing out, yeah, we know that he walked in and he shot the judge, you know, point blank. We just saw that in the video. I don't know. I don't think anybody else will be able to bond out on a homicide charge like that. I don't. So I'm kind of with the state on this one. I don't think he should necessarily be able to bond out. You know, we're bringing up his mental state as an issue, and it's pretty apparent who did what and why. Well, not why, but that he, you know, there's a whole damn video showing what he did.
Still,
Your Honor, if I may respond, she went into a lot of the statutes. Unfortunately, she forgot the Kentucky Constitution, section 16 says that all people are entitled to bail unless there's a capital offense. And the word she was looking for is when proof is evident, the presumption is great. There's just recently in 2024, a Kentucky Supreme Court case on this issue. It was out of Breckenridge County, if I'm not mistaken. The site on that is 2024 WL 298-2769. That is a case in which, much like we are sitting here today, the defendant was charged with capital offenses. The Commonwealth had made a statement on the record they were not seeking death in that case. That statement made at that point in time, the judge set a bond over the Commonwealth's objection. The Commonwealth then filed an appeal on that issue. Supreme Court come back and did the exact analysis they're asking you to do. And basically, what he did in the community, what he did is irrelevant. The only thing that's relevant is, in fact, the charges themselves. And the Supreme Court said, if you are charged with a capital offense, you are not entitled to bail. And they overturned a circuit judge and sent it back to the no bail. So there's a case already up at the Supreme Court issued last year. I gave the citation for it. And the case number on that is, or the case name on that one, I don't think I gave you that, is Commonwealth versus Rodney Jones. And Judge, there's enough in the record already. You can take judicial notice. That's why the Commonwealth introduced the video here at the preliminary hearing. It's very clear what happens in the preliminary hearing. They were counseled record at the time, so there's not an issue. They did cross-examination of that. The record is very clear. The video is very clear. And Mr. Stein, in fact, took the life of Mr. Mulliens. So,
And again, they're referencing the video that we just played where he walks into the judge's chambers and shoots him point blank.
that's all that's required. Even under the case law, the Constitution, he is not entitled to bail.
Hold on.
Yeah, if I could briefly respond. I do have a piece of case law I can cite here, Judge. It's Burton v. Commonwealth. It is an older case. It's 212 Southwest 2nd, 2010. Judge does show that the court can take into consideration the mental state of the defendant when.
So now they're going to argue the mental state of the defendant when it comes to bail and the fact that his mental state's not that great and considering bail. We'll watch this one this time and see if it's any longer.
The just released video from an Eastern Kentucky courthouse makes it crystal clear.
It's a short, so I'm just showing you for those of you that just came in. All right, play it.
Stands out for me. What most people are under the impression is happening, where the guy comes in, the sheriff comes in, is relaxed, and the judge is relaxed. That's not what's happening at all, not even a little bit.
And he's
when that guy
smoking a
walks
cigarette.
in, watch what he does. His body language is really tight. He's moving constantly. He's going back and forth. Then he goes back and he makes a threat check. You'll see in just a minute, into the other room when he turns around and looks. And that threat check is to make sure it's okay that he can do something. Watch the judge. No, at this point, he's trying to look relaxed. That's what that looks like. And we know that because how stiff his arms are. They're straight. And now he's going to stay in that position pretty much the whole time. His hand's going to go back and forth, but he's using his hand as a barrier. He's afraid of this guy. Something's up. There's some kind of relationship between these guys. I'm not saying they had a relationship themselves, but something's going on before all this, because this big guy, the sheriff came in and he's got something on his mind. If I was a betting man, I would say he came in to do what he did. I don't think what was on the phone triggered him to do that. I think he was making the sort of preamble to say, here's why I'm doing this. I'm proving this to you. This is wrong. This shouldn't be happening, whatever it is. And that's when he gets up and does that.
Okay, and what he does, that one didn't show that, but that gives us beforehand. Evidently, allegedly, he called his daughter. This is the actual video up here. He called his daughter supposedly from his phone. She didn't answer, so she tried to call from the judge's phone, and she answered his, allegedly. And there you can see he's shooting the sheriff, and he shoots him one more time. You're going to hear the family cry. Hey, Reaction Buffet. Aw. Okay, and I'm going to jump back over to where they're arguing the mental state of a defendant can come into play when we're talking about bond. And then he walks, in that video, he walks out of the room and he turns himself in and puts his gun on the, in the courthouse on the counter. Reaction Buffet, thank you for being a member for a month. Said, thank you for the gifted membership. I am so glad you were gifted, sweetheart. And thank you for saying thank you. Oh my goodness. And then you just came in and dropped 5. Well, thank you for that. That was very sweet of you. Those went to Mama09, Cat Not Cat, Shanna, Kez Z, and Cara Stevenson. Thank you so much for gifting those memberships, Reaction Buffet. If you were gifted and you are aware you were gifted, please tell Reaction thank you. Thank you so much, Reaction. And I will grab the crazy train to pick our new members up on the way to Speculation Station. Thank you so much. We do have a new video of Basil. I wanted to make sure I got something out for you, for the new members. And so there is a new video of Basil out that I put out yesterday and some mushrooms that I ate. Basil is here. He was just demanding attention while we were watching that video. Michelle Demantis has been a member for 8 months. We almost got a YouTube baby, Stalky. Michelle said, woohoo, 8 months for me. That's awesome. Thank you for being here for 8 months. I really appreciate that. Those of you who are just now seeing it, yeah, that's what we're talking about. It's one of the first cases I covered. All right, back to this. She's about to argue the mental state of a defendant can come into play when we're talking about bond.
Setting bond in a capital case. So if this case was basically where evidence introduced in a hearing on motion for bail showed defendant to not be guilty of murder, but only voluntary manslaughter, in the event that the jury did not find self-defense, the proof of guilt was not evident, nor the presumption, right? So I think the court can take that mens rea into consideration and that mental health evidence into consideration, which is again why we want to be able to introduce that.
All right, thank you. In response,
Judge, I believe the case I cited speaks right to the issue.
All right. All right, as with the other issue, like I said, here's what I'm gonna do. Mr. Steele, you said that you all would file a written response on the KCPC evaluation within 10 days. So
On a motion to unseal?
Yeah.
Yes, sure.
Why don't we do this? If anybody wishes to submit case law or supplement anything in regards to the pleadings on all 3 of these matters, if both sides will do it simultaneously within 10 days.
Within 10 days, Your Honor?
Within 10 days.
Yes, sir.
Yes, sir.
And then that'll give us time. I'm going to try and expedite rulings on this, and then we can start looking realistically more at setting a next hearing. And I think once we get these initial matters addressed, we can then start realistically looking at potential trial date.
Yes, sure.
For all parties. So
I have one thing, Judge,
sure.
Can we do 10 days from Monday since today's kind of
10
shot next week?
days from, why don't we do this 2 weeks from today?
Yes, Your Honor.
That work?
Yes, Your Honor.
Yes, sir.
Or you want the weekend and add one more Monday?
Okay.
Your motions.
I'd rather under promise and over deliver, Your Honor.
All right, why don't we do this? And both sides will have till Tuesday, September 2nd.
Yes, Your Honor.
That should give everybody plenty of time.
Thank you, sir.
All right, and then after I get those pleadings, I will notify the parties and we'll get a more realistic timeline on when we'll set the next hearing.
Yes,
All
sure.
right, other than these 3 matters, I know we have one matter that we'll have to address ex parte that we'll talk about in just a minute. And for purpose of the record, the Commonwealth, you've been given notice that they filed for an ex parte hearing in regards to funding.
Yes, Your Honor.
And you're aware that the court will address that at the conclusion.
Absolutely, Judge. And just to make the parties aware of talk those in chambers, we are looking for an expert on this issue. And
sure.
And there's funny channels we have to go through depending on what those come back as for an expert also. So we made counsel aware of that also.
All right. Thank you, Mr. Steele. Anything else we need to address today before we adjourn before the ex parte hearing?
Nothing
No,
more
you're
to come.
All right. Ladies and gentlemen, pursuant to the rules, what we're about ready to have an ex parte hearing in regards to one matter. I'm going to be in recess for about 5 minutes. It's a good time for the courtroom to be cleared. Obviously, defense counsel, the defendant will be able to remain for that part of the hearing.
Yes, sir. I think Your Honor would like to.
What's that?
Yes, Your Honor. We wanted to talk to him for just a minute.
Yeah, absolutely.
Take care.
All rise.
Okay, let me see if they're back in court because they're talking about another hearing. And I don't want them to be doing nothing behind the scenes, if I'm being honest. Let's not be doing anything behind the scenes. All right. Thank y'all for being here again. Now, let's talk about why we're in Kentucky. Let me pull this up on my phone just to see if they come back. Because if they do, we'll jump back and it'll be live. Hold on. I will pull it up in my history. Hold on just a minute. Okay, I don't want the channel. I want my history. No, it ended. I guess the ex parte order. Oh, wait a minute. Yeah, this is Georgia versus Christopher Wolfenberger. So, baby, I can't pet you right now. I'm working. I love you. Okay. Let's go over here. Hold on. All right, since we're talking about Kentucky, we're going to go over and talk about Jayden Spicer. Now, she appeared in court. She had her first court appearance, and she looks very nervous, very disheveled, and she's in the turtle suit, which basically is a Velcro suit, so that you can't hurt yourself, and you're nude underneath. I wish we had more video of the actual hearing. We do have part of this here. We do have this video, which we're going to watch. And this is all I found so far. But she pled not guilty so far. I'll have to wait a minute while they do the daggum advertisement. Hold on.
Not guilty plea was entered for a Breathitt County mother.
There we go.
Accused of killing her 10-year-old son.
Jayden Spicer was found dead Tuesday near Canoe Road in Breathitt County. His mother, Felicia Gross, was arrested and charged with second-degree manslaughter, abuse of a corpse, and tampering with evidence and witnesses. She was in court today.
According to an arrest citation, Gross confessed to police that she gave Jayden sleep medication she believes caused him to have a medical emergency that killed him. It goes on to say that Gross told police that she later took Jayden's body to a wooded area and buried his remains underground in a plastic tote. Community members say they were shocked and devastated when they heard the news.
You just don't think something could happen here in your hometown. But when it did, I was like, oh, wow, that's, mind-blowing to me.
Kentuckians are mourning Jayden. Last night, the community came together to hold a prayer vigil for him. His aunt, Samantha Brunty, and Chai Sailors worked closely with state police to help during the search. They say the days leading up to the discovery of his body were some of the hardest of their lives.
Now they're going to talk. Y'all let me know what you think, because I still don't know if CPS gave Jayden back to Felicia or if the aunts gave him back to Felicia because she was working a full-time job and had 5 kids. I'm still not understanding if it was the aunt who gave Jayden back or if it was CPS. If you guys know, let me know. I'll check that, Cara. Oh, yeah, she confessed. I actually have the citation we'll look at after this video real quick.
I just hope and pray that that baby has his final moments of resting and everybody can know that he is safe.
He was full of light, always smiling, and he just loved being around his family and friends, and he was a happy kid.
Jayden's aunts say their family is heartbroken right now, but add the outpouring of community support will help them and their family heal. Gross will be back in court Monday for a preliminary hearing. We expect to get detective testimony. We will continue following the latest from this investigation into Jayden's death and how the community is honoring his life.
Okay. So that was that was what they said about her court appearance today. She pled not guilty. I'm going to read this. It says, Breathitt County, Kentucky, the Kentucky mother accused of the death of her 10-year-old son, Jayden Spicer, made her first court appearance on Tuesday morning. A not guilty plea was entered for Felicia Gross. Again, she pled not guilty. She is facing charges of manslaughter, abuse of a corpse, tampering with evidence, and witness tampering. Jayden was found deceased Thursday night near Canoe Road in Breathitt County. And we mapped that out in a previous live and showed that it didn't appear to be very close to where the grandmother was originally buried to me. It says, according to an arrest citation, Gross admitted to giving Jayden a type of sleeping medication, believing it caused a fatal medical emergency. She told investigators she took his body to a wooded area on Canoe Road near Joe Little Fork, where it was buried in a plastic tote. Gross is scheduled to be back in court on August 18th. This is a developing story. Now, I have a few things. We're going to jump over here. I am going to put up a speculation banner because while this does appear to be a legal document, I am not sure. Baby, honey, hold on a minute. Sweetheart, I can't hold you. I'm working. Here. Do you want some crackers? Don't do it. Here, baby. Leave my toes alone, Basil. Here. Get you some crackers and go lay down. Quick. Boy, I'm going to put you in the kitchen. Quit it. Okay, sorry about that, y'all. All right, so this is the citation. We're going to zoom that on up. So it's the Commonwealth of Kentucky, uniform citation, Kentucky State Police Post 13 versus Felicia Gross on Pine Bowl Road. She's married. The victim's relationship to offender was her son. Her sex is female. All of the things. She was born October 17th of 1991. Okay, so we're going to it's in Breathitt County, Jackson City, Kentucky. Charge 1, false report in an incident to law enforcement. I do believe that's going to be because she reported Jayden missing, even though he wasn't. Charge 2 is manslaughter in the second degree. Parabola, you're good. We started with Mickey Stines. We're just getting into this. Charge 3 is tampering with physical evidence. Charge 4 is abuse of a corpse. It says on August 6th of 2025, Miss Felicia and Josh Gross reported that their juvenile child, Jayden Spicer, went missing the night of August 5th into August 6th, and his whereabouts were unknown. A recorded Mirandized interview was conducted with Miss Gross on August 12th at the Jackson Police Department, where she confessed to providing Jayden a type of sleeping medication. Miss Gross further stated that this medication caused Jayden to have a medical emergency, and she believed that he passed away from this medical emergency. Miss Gross further stated in the interview that she had transported Jayden's body to a wooded area on Canoe Road near the mouth of Joe Little Fork. A search warrant was prepared and executed on this property, and Jayden's remains were located buried underground in a plastic tote. Now, this is weird to me because remember we watched that interview and that one guy who was supposedly like a politician or something in the town said that he knew where to look and he just looked and found it. So maybe I misunderstood. Maybe she confessed and they had an idea of where it was at and then he looked and found it. But I thought he was saying that they found the tote and then the police went to Felicia and that's when she confessed. I guess I misunderstood that originally, but those of you that were here that saw the video, it was a bit misleading, I think. Hold on. Oh, I love lion heads. My daughter won a rabbit that looked just like Basil, and she was a big girl, just like, oh. Basil is a boy. That's so sweet. I haven't seen there. He had I saved Basil. He had 5 siblings, and the mother didn't take to him, and I was able to keep him alive. Rabbits are very hard to keep alive. All right, so that's the end of that one, and then there's another one that talks about the. No, that's just that. She's also gotten charged for tampering with witnesses because she told Jayden's siblings what to say, basically. Oh, sorry, wrong one. Okay, I went the wrong way. All right, so this is his obituary. Jayden Spicer, age 10, of Canoe, Kentucky, passed away Tuesday, August 12th of 2025. He was born October 4th, 2014 at Hazard Appalachian Regional Hospital. Jayden. Okay, I'm going to try this again because I messed it up and that's just not going to work for me. So this is his obituary. Jayden Spicer, age 10, of Canoe, Kentucky, passed away Tuesday, August 12th of 2025. He was born October 4th of 2014 at Hazard Appalachian Regional Hospital. Jayden was a bright and energetic student at Highland Turner Elementary School in Breathitt County, preparing to enter the 4th grade. He loved life with a joyful spirit and touched everyone around him. Jayden enjoyed playing Fortnite and Roblox, was a big fan of Spider-Man, and spent countless hours playing outside, throwing rocks, riding the four-wheeler, jumping on the trampoline, and playing soccer, basketball, and baseball. He is survived by his aunts Samantha Brutney and Shy Sailors, uncle Michael Hayes, sisters Mia Spicer and Aaliyah Spicer, brothers Hunter Gross, River Gross, and Fisher Gross, and a, quote, like a grandmother, Linda Slayers. Oh, and someone who was like a grandmother to him, Linda Sailors. He also leaves behind a host of cousins and many dear friends who will miss him deeply. Jayden was preceded in death by his grandmother, Shirley Faye Johnson, who lovingly raised him until her passing in May of this year. Jayden's playful laughter, kind heart, and adventurous nature will remain in the hearts of all who knew him. Though his time here was far too short, the love he shared will last forever. Sad. So this is just the document again, and there's a beautiful picture of Jayden. Mr. Waffles. Oh, thank you, Michelle. Okay. I don't know. I don't know what the hell's going on. Okay. Now this is going to be about BrYan. So that's all I have on Felicia. I'm going to see if I can get I'm going to search real quick. I'll pull this up and see if we can watch the whole preliminary hearing for, not preliminary hearing, first hearing for Felicia. These are articles. We have this one, but I don't know if it's going to be like the actual hearing. No, that one's not the hearing. But
the mom was charged earlier this week in the death of her 10-year-old son, Jayden Spicer. She admitted to giving her son sleeping medication and said that she believed her son died from a medical emergency before authorities found his body buried. In Kentucky, defendant Felicia Gross entered.
All right. So that's all. I saw that one earlier, but that's all that I've found so far. Yeah, this one's just an article. All right. So we'll talk about Bria Kohburger. There's a video of him in jail, and like everybody's like, what is he doing? I can't figure out what he's doing. I know what he's doing. So we'll talk about that real quick. And then as I got on my computer to start the live, I noticed that there was a new video out that I haven't gone over that we can talk about real quick that I have pulled up. First, let's talk about this little short Bria Kohburger video. So here he is. He places something. We're going to watch it a few times. He places something up there. He stands and he's looking around and he's looking up. And nobody knows what he's doing right there. I do. There, he's cleaning his shoe. Remember, they talk about the OCD, very meticulously cleaning his shoe. All right, so he places that napkin or paper there. I want to see if y'all know. Oh, that's some kind of music. It's not what goes with it. They don't have audio on those. And that's the OCD. What do you guys think he's doing when he's just staring up? BrYan Incel or BrYan Incel? Hey, Jeff, good to see you. I know, Reaction Buffet. It was so sad. I don't think there is. What I think he's doing, remember they talked about them talking through the vents? The vents in a jail cell are always up towards the ceiling. I really think that he is putting whatever that is there, a paper, a napkin, and he's standing there and he's listening to see what the people are saying through the vent. Like, that's the first thing I said. He's looking at the vent and now he's turning his head to the side to listen to what they're saying to him. That's really what I think is going on. Jeff said, I wonder if the clips are in reverse order to how they actually happened. Maybe he cleaned his shoes and then put what he cleaned them with up on the shelf. Oh, good point. That makes a lot of sense. I didn't even think about that either. So Jeff figured that out, and I really believe he's looking up at that vent and listening to what they're saying. You know, and now that you say that, Michelle, that he's going to block that vent. Yeah, that's exactly what it was, Jeff, because there he is cleaning his shoe, and he puts the thing on top of the shelf that he cleaned his shoe with, and now he's listening. There were women that would take in wet toilet paper and they would put it over the vent, but they, you know, we talked in our vents. We wanted to talk to each other because we were locked down for several hours a day. And they would put toilet paper over the vent because it was always blowing so cold and we'd be in there freezing. You think he's listening to Dainty? Oh, good to see you. Jerry said he's so creepy looking. Starkey Pit said, I saw on another channel he put complaints about them talking about him through the vents and talking to him to the vents. I heard that too. And I think that they had said that there's nothing they can do about it because they're just talking to him, not threatening him or anything. And I find it funny because Steve Gonzalez was like, I'm going to have some people waiting for him when he gets there. CPS gave him, Cindy, I think you're behind, but yeah, it looks like he's listening, right? He better not be. That's creepy to think about him watching me. Okay. I really think that's what he's doing. He's listening to what they're saying in the vent. Is he got like a lump on his back, like a weird spine? Jeff called it on that he put that paper he wiped his shoe off with up there. So I heard that he washes his hands a ridiculous amount of times a day. Yeah. The guards are like, yeah, we don't care. Welcome to prison. Okay. And then this that I have is about him. I think somebody's talking to him in there, but I don't know. This is just speculation. I found this while I was looking for that video today, and it says, I just sent a text message asking if he could send me some new ones. I will post as I get more video and info. Also, yes, he's being harassed 24/7, and they do not care and do not stop any of it. They just ignore all the stuff the inmates do since they are in their cells and can't get to each other. They have done this for years. Did the same to Chad Daybell, kid killer, so they have a target on him, but he's at least on death row. He said BrYan washes his hands constantly and is washing everything else nonstop. His hands are always red and almost bloody dry looking from it. He also freaked out and bashed his head into the wall while watching football and was yelling at it. He's observed 24/7, as they all are. So I guess this person's with the CO. And if we go back to this video, I was noticing that you can see when he holds his hands in front of him, like they are red. That's what made me think about him washing his hands. See how red his hands are right there? Look how red his hands are from washing his hands so much. I have OCD, the germ variety. I wash my hands with soap and fingernail brush. Do you do it as much as you think he does? Yeah, his cell is bigger than I pictured too. Ours were not that big. And he's got what looks like a medical bed. That bed looks like a medical bed, not the standard like on the metal bunk bed. Like when we saw AustinDrummond, that was the kind of beds we had, but we were in an open area. All right, we can go over here real quick. This is a new surveillance video from the night of the homicides. I hadn't seen it yet. You guys might have, I don't know. But it was when I pulled this from here, from MSN, when I was opening my computer, it was like 5 hours old, I think. So this is going to be November 13th, 2022 at 1122 King Road. Or it might be the video from across the street because that's the house right there.
Released surveillance footage, authorities say, shows confessed killer Bria Kohburger driving around the house where minutes later he would murder 4 University of Idaho students. His white Hyundai Elantra seen circling the neighborhood several times, making 3 passes by that King Road home between 3:30 and 3:58 a.m., minutes before investigators say he entered the home. Around 4:17 a.m., you hear what sounds like a voice, followed by a loud
Stop. Why? No, we're not going to do that.
Confessed killer Bria Kohburger sounds like a voice.
Lord have mercy. Hold on. I got it off my computer, so it's going to play ads, I guess. I'll try to make it big in a second because this is just like my home screen or whatever.
Followed by a loud thud. Then a dog can be heard barking. Investigators say that was a prominent sound.
The dog barking is probably the most consistent noise on that video.
The car seen leaving at a high rate of speed around 4:20 a.m., careening around the street. He tried to hide his movements by disabling his Wi-Fi and manually powering down his phone, according to the digital forensic experts who analyzed his devices. But less than 2 hours later, he was calling his parents, 11 interactions with them the day of the murders. The experts also saying they found evidence of disturbing search history on Kohburger's devices weeks after the murders, including Christmas night.
Bria Kohburger spent a majority of
Christmas night.
his night on Christmas
doing
a deep dive on serial killers.
I mean, it was ridiculous details about all of these different serial killers, and he just clicked one after the other after the other.
Wow, that's interesting. Michelle said the cell is way larger than it should be. In my opinion, Lori Daybell's cell was way smaller than that. I've never seen one that big, but I've never been on death row. I've never been to prison. You know, I've been to jail, but we had like a dorm type thing where there was the metal bunk beds like you saw in the video of AustinDrummond, and they were bolted to the floor, like, and then, you know, at the day room and stuff, like it was just one big room. And then I've been to somewhere I had a cell, and those beds are like made in, like they connect to the wall. It's not like a bunk bed either. It's like connected to the wall. It's weird. I'd have to show you. It's hard to describe. Dolly said, I saw on the news that the police redacted something DM said. BrYan actually said, I'm here to help you, Kaylee. That's what the news channel reported this morning. I'm still speculative of the motive. Interesting. Was it stated that he was only actually targeting one of the 3 girls, like he was obsessed with her? I've heard that, but I haven't verified it. The murder house is behind this camera and to the left. Okay. We'll back it up. I'm not fully up on this case, but I'm wondering if his parents have been brought up in any way for maybe helping him. Not yet. Lawyer really wanted him off death row, and I think he should have been on death row. I'm going to back it
And
up.
while forensic evidence revealed no direct link to the victims, they do say that he used Google Maps to search for the Mad Greek. That's the restaurant where both Mogan and Kernodle work.
So he might have been targeting Maddie Mogan. Okay. So Jeff said the house is, so it's not this one, it's this one over here. Let me pull that comment back up because I could have had it wrong. I don't know a lot about this case like a lot of you do. The murder house is behind the camera and to the left. Not over here. Back over here where the thing is? I don't think so. I thought it was this one. I thought that was like the back side or something. Something tells me at the very least his father knew something. They suspected him from what I understand, like right after it happened, his sister turned him in. Oh yeah, his cell will probably be the cleanest cell in that damn place. Do we know for sure that that is prison footage from recently? Well, I think it just got released as of like last night or yesterday. Very, very recent as far as I know. I think the house, hold on, let me pull it up. Okay. See, there's the house right here. So I really feel like the camera we're looking at is basically from this angle. Like if we back up a little bit and get out of the road and just walk directly backwards, we would be looking directly at the house as we are here. Like I feel like right there's the road that we're standing at in that picture, and that's the house. But over here, the house is boarded up. Right? You can't see it? Really? So that's not it. Okay. All right, let me.
Minutes before investigators say he entered the home.
Oh, there he
Around
is driving.
4:17 a.m.,
Okay.
you hear what sounds like a voice, followed by a loud thud. Then a dog can be heard barking.
Okay, so it showed him driving by to the right. So, okay. All right. Well, thank y'all for helping me figure that out because I thought it was of the house. Okay. We can go back over here, but I think this was just released. Like I think it was just found yesterday, maybe the day before. He's definitely listening. Yeah, BrYan. That's not his prison cell. That's his jail cell. He doesn't have dress shoes in prison to polish. No more court, no more suits. No, okay. So do you see court shoes? I thought he was polishing a crock or something. Oh yeah, that is a Yeah, it's a crock. I think it's like a prison issued crock. He's in a medical cell because they got the handle by the toilet. Bella said, I see a big asshole. All right. So I saved a couple of things. We are going to talk about a case that I requested FOIA information on, and we are going to talk about that. Let me see. I threw some stuff over here. Okay. We do have this real quick about AustinDrummond. It's an exclusive. AustinDrummond's attorney spoke to the news, and so I was going to play that real quick, and then we'll jump into this new case that we're going to talk about. I don't want to mute
this, and tell me, have you spoken to him much since this? And how does he feel about having you appointed counsel?
I've talked to him a couple times. In fact, I just left the jail here, and I have spoken with him a couple times. He's comfortable with me. I've been doing this for 20 years.
Mm-hmm.
And so, of course, early on in the case, so we've got to really kind of investigate all the information that I've received from the DA. Of course, a lot of information is going to continue to come in. So the case is going to evolve. Not exactly sure where it's going to go, but it's going to be a long case.
Also, Drummond asked about his girlfriend and the restraining order. You entered that in.
Right.
So is that to do with him wanting to speak to Caitlin, or?
Yeah, that's his girlfriend, and the restraining order is a blanket order restricting him from talking to basically anybody who's related to that family, and of course she is. So talking to the judge, he wants to hear a little bit more information about everything, and of course if she wants to speak with him, she's going to need to go talk to the judge and tell him that she wants the restraining order lifted at least as to her.
Yeah.
I don't think that they're going to let him talk to Caitlin because of her proximity to the family, like the relation. It could jeopardize the trial, I would think. I forget who, but someone said Aryan Brotherhood may not want him because he's smart, but I hope his prison experiences go very, very wrong. I don't know how strong the Aryan Brotherhood would be there. When I think of Aryan Brotherhood, I think about Texas and stuff. I think, unfortunately, as bad as it's going to upset everybody, if he is allowed out to where he can talk to people, I mean, it sounds like they're hounding for him, but eventually, or if he gets moved, people will talk to him because he was so high up in criminology. And one thing that the best thing to be if you find yourself in a situation like that is somebody who is educated on the justice system, because you become what they call a jailhouse lawyer. And you give people advice on their cases in exchange for money or ramen or whatever. Crocs are on the floor and they're orange. Those are his slides, and then it looks like, I'll go back to it in just a second. It looked like he had a pair of black Crocs and then his orange slides. His shower shoes, basically, is what they called them when we were there, but we only got the orange slides.
Understand. And then do you know if she's concerned about the pregnancy? Has she wanted to talk to Drummond about that, Austin, about that?
I don't know.
Okay.
I'm not sure on the details of that, but
okay, great. And then also, do you have any more information just in regards to like how he's doing? I know he did ask twice now for a speedy trial.
Right. With the speedy trial, obviously we want to take the trial as fast as possible, but we certainly want to be ready. So we want to thoroughly investigate the case to be able to be prepared to defend the case. He's holding up pretty well under the circumstances. Of course, they're keeping him separate, for obvious reasons, especially because it's a capital case.
And tell me again where he's being held.
He's obviously we're in Lake County today, but he's being held in Obion County.
Obion County.
Yeah.
All right. Thank you, sir. And can you just spell your first and last?
Okay. Oh, it went right back to this. All right. So he could be in the medical part of the jail. They might, hey, Rogue, good to see you. They might not have moved him to prison yet. I'm going to mute it again because the song is just okay. Anyway, he might not have gotten moved to Department of Corrections yet, but I don't know. I mean, they're acting like this new thing where they're talking to him from the vents and through the toilet is like a new thing. So I would think that just started happening when he got moved to DOC, and I could be wrong about that. Y'all are saying that he's actually still in the jail. It is normal for you not to be moved to DOC. Actually, you know what? We can solve this all right now, and I could, I could have done this. Let's see. I've got to make sure we put that Y, Miss Alaska. Okay, it says Bria Kohburger is currently in solitary confinement at the Idaho Maximum Security Institution. He has been transferred to long-term restrictive housing where he will spend most of his time alone and has limited outdoor reaction. The facility is designed for inmates who are considered to be a risk for self-harm or violence. And again, as of August 2nd, it says Bria Kohburger has been transferred to a long-term restrictive housing in J Block at the Idaho Maximum Security Institution. Prison documents confirmed on Saturday, August 2nd. Now, the video was shared in the past day or two. I don't know if it's from the Department of Corrections or not. We'll go right back to that to talk about the shoes. The screenshot I have, it seems to be from somebody who knows a CO there, and they're saying, I just sent a text asking if he would send me some new videos. I will post as I get more videos and infos. Also, yes, he's being harassed 24/7. Also, they do not care and do not try to stop it. They just ignore all the stuff the inmates do since they are in their cells and can't get to each other, which they do. That's true. They have done this for years, did the same to Chad Daybell, kid killer, so they have a target on him, but he's at least on death row. He said BrYan washes his hands constantly and is washing everything else nonstop. His hands are always red and almost bloody, dry, looking from it. He also freaked out and bashed his head in the wall while watching football and was yelling at it. He's observed 24/7, as they all are. And that makes sense. I mean, it lines up with this video that I'm seeing here. So I do believe it's from the institution. I do believe he's having a fit because as he got there, they started talking to him through the vents and screaming through the vents. He has a pair of what appear to be like Converse shoes on, and that's what they give you at the DOC. These are Crocs, and I'll pause it so you can see that. And then these orange shoes are the slides, which is what you would have in jail. That's the only shoes you're usually given in jail, and they're also called shower shoes. So they're in reverse, like Jeff pointed out. He put the tissue up that he was washing the Crocs with and is listening because I think they're hollering at him through the vent, and he's trying to hear what they're saying. Okay, this is the shoe. It looks like a court shoe right there, okay, where he's washing it. Now watch. You see the slide, you see the back part right there? That's a Croc. Can y'all see the little strap that you pull up? Oh, he is saving everything. I made it a little bit bigger. Yeah, I think it's just that when you go to jail, you're issued a pair of Crocs, a pair of slides, and then the pair of like tennis shoes. Blue Jay said, I seen that it said he was in jail, but I thought they were orange. Yeah, I think this is Department of Corrections. In jail, you normally also would have on either orange or the stripes. I don't know if they're actually Converse. They look like the Converse. I call them Converse, but they might be an off-brand. I don't know. Shower shoes are a must. My goodness, I'm not OCD, and that would be my first purchase if not issued. Yeah, you can wear those shoes. They're like I mean, they're made out of the same material, but they're slides. So you wear them in the shower and keeps your feet from getting dirty. Or white. In Arkansas, we wear white. Really? I didn't know that. I wonder if he's saving it because he knows he's limited on how much tissue he gets. Maybe. Yeah, Converse. Yeah, but that's definitely a Croc in my opinion because it's got the strap on the back. Now, maybe he had them for court. Like they do have nice looking Crocs now. I don't know, but it's definitely a Croc. Not gonna lie, I hope he has to go number 2 and has no toilet paper to wipe. Him having to sit with a dirty booty until they decide to give him more. He does have lots of shoes, but not as many as AustinDrummond. That's for sure. Wanted to show y'all since we're talking about the way we spell things and trolls. I put in 3 new clips. I want to show y'all. We'll take a palate cleanser real quick before we get into this other case that I did to show y'all. I want to show y'all a funny video and then 2 clips that I have. This clip is for trolls.
You don't tell me what I have to have. You ain't my mama. You overstepping your goddamn authority. Now don't try to be my motherfucking girl, please. I don't want to do that. Because I love you. You my granddaughter. You done so much. But you about to step out of line and I'm going to fuck your ass up.
That's my troll clip. You overstepping your goddamn authority. Okay, this one is like the whole video, but I titled it Crackheads.
He picked me up and we were going to Mama's work. Mama's window was busted.
What happened? Who did it?
A crackhead.
She
stole her wallet.
She's so
broke
serious.
Your mama's window and stole her wallet?
Yeah, her wallet. And there was her window. It was her truck. And I was told on the way back home.
She is so cute. Yeah, all the humanity, the serial killer's name was spelled wrong. I wish I had that troll clip yesterday. And then I'm going to show y'all this whole video since we're doing what they call a palate cleanser. But I have this one titled Murder Was the Case.
Oh, she trying to 187 type shit?
Bruh, double homicide. Yes.
Murder was the case?
Murder was the case.
All right, I'm going to show y'all that whole clip because it's hilarious, I think. Not hilarious, but it's funny to me. All right, let's go to that. My favorite one, though, is the troll one. While I get that clip, I'll play the troll one more time.
You don't tell me what I have to have. You ain't my mama. You overstepping your goddamn authority. Now don't try to be my motherfucking girl, please. I don't want to do that. Because I love you. You my granddaughter. You done so much. But you about to step out of line and I'm going to fuck your ass up.
So trolls beware. All right, this is the other clip that I thought was just it's titled "This Lives in My Head Rent Free," and it kind of lived in mine rent free as well. If I can find it, where is it? Yeah, it's this one. Hold on.
Hey, what's happening?
Top block with the homies. Say, what's up, boom?
Hey, what's happening?
Top in with us. Where the bitches out there? Yes, sir. We trying to kick it.
Hey, Jojo.
Bro, my girl got you on there. I told you that.
Wait, so why haven't you blocked her from?
I blocked her already on my phone, but I can't do that on your account, bro.
What?
She sees everything you post.
Oh.
Remember the last time you was mentioning bitches?
Huh?
I didn't get in the fade, bro. She blacked my eye.
Oh, the homegirl abusive.
Yeah, bro. Abusive.
The homegirl domestic violence.
Yes, bro.
But fool, but your horse will be my horse and my horse will be your
We
horse.
don't have no horse if we both dead, bro. How the fuck we gonna play that role if we both dead?
Oh, she trying to 187 type shit?
Bro, double homicide. Yes.
Murder was the case?
Murder was the case.
The homegirl death row. But then just leave her, fool. She's probably weird, fool. She's a weirdo, fool.
It's like I'm addicted to this shit. I don't know. I can't explain it to you, bro.
You're addicted to bitches punching you in the face?
It's easier said than done, bro. I can't. I don't know, bro.
Why are you scared of her?
Bro, you would be
Look at your face. You look scared.
Are you currently working?
I'm in jail.
What is 372?
Numbers.
I thought that was funny. He said, "Oh, the homegirl abusive." Okay. All right, let's get back on topic now that I played my funny clips. Honestly, going back to Bria Kohburger, I hope he has to sit with a dirty booty too and wait for them to bring him toilet paper. The homegirl abusive. Okay. Not that that's funny. That's not a funny situation, but the way he said it was funny. All right. So I saw this case a couple of days ago and I pulled information on it. And so we're going to talk about it. I'm going to show y'all the video so you kind of know what it is. And then we're going to listen to the records that I have on it. And then we'll go back to this video.
Why walk to?
Okay, hold on. I want you to see like a picture. Basically, I'm doing this so you can see the people that we're talking about and get an idea of what the case is. So we're going to play the first part of this, and then I'm going to go to the files that I have on it so far, and we're going to check those out.
I'll listen to you. A 14-year-old boy faces new charges in the murders of his parents after the sheriff said he called 911 and confessed. I look at the new information we're learning about the case of Trevor Lee out of Florida.
So that's a murder was a case? Yeah, so that's what we have right now. 14-year-old boy named Trevor Lee out of Florida shot his parents. His name is Trevor Eugene Lee. The photo was taken August 4th of 2025. Okay. Now, these are like FOIA documents that I have. Yeah, it's happening a lot. Isn't it, Dainty? It's scary. They said too that like the fact that I thought that I said he committed after committing homicides of 4 college students or whatever, after committing 4 homicides, and they were like, if you think that he did it alone, I was like, well, we could have, discussed the fact that you don't think that Bria Kohburger did it alone, but like you acting like an asshole, it ain't gonna get nowhere. That's something we could have talked about if you feel differently, but like yelling at me in the chat's not gonna make me talk about it. Okay. So it says that it says that Trevor Eugene Lee, whose date of birth was 2010. Wait a minute. Yeah, 2010. So what, 25? Wait a minute. It says, anyway, he committed homicide not premeditated in the second degree and homicide not premeditated in the second degree of his parents. On the 3rd day of August 2025 at 12:30 a.m., the defendant within Clay County violated the law and did then and there commit the offense of second-degree homicide not premeditated, contrary to Florida statutes. On August 4th of 2025, deputies responded to Cross Point Church in reference to a homicide investigation. Deputies made contact with 14-year-old Trevor Lee, the defendant, who was still on the phone with Clay County Dispatch, advising the defendant was taken into custody in the parking lot of Cross Point Church without incident and transported to the Orange Park substation in a marked patrol unit. Both his mom and his dad are now deceased, and he did it. Defendant was read his Miranda warnings and he agreed to speak to us and then signed a form stating as such. Detailed statements received during the interview may not be specified within this report. The following is a summary. They redacted it. The defendant also called into the Clay County Sheriff's Office to advise. They redacted. The phone number that the defendant called from was confirmed to be his cell phone. Deputies responded to the residence and located victim 1 and victim 2 in their bedroom with multiple gunshot wounds. Clay County Fire and Rescue confirmed both victims were deceased. Several spent shell casings were observed in the bedroom. The defendant was then processed into the Orange Park substation. The defendant was transported to the Duval Juvenile Detention Center. And that's all we have on that. All right. So I'm going to see if I can pull this up. I'm going to have to pull it up through Media Player because I'm kind of going through it with you guys. Let me know if you can hear it. when I push play. I'm going to push play, and if you can't hear it, let me know. It's playing. It's quiet. Hold on. You can't hear it? Hold on. It keeps redacting. Hold on. Dang it. Like, what am I doing? They're trying to, they keep, like, redacting part of it. Let me try to pull it up again. We might try it like that. Okay. Can you hear it? It's quiet right now. Okay. Say, who the fuck does that, bro? Okay. We'll listen to, I guess we'll play the Law and Crime version of it today and then go back to it. I'll try this one and see if y'all can hear it better. They redacted it, but can you hear this one better? It's quiet. Hold on. Well, now it's nothing. They redacted it. Can you hear this one? Do y'all hear it? Better, but you can't make it out. He said I need to pray, and he's at the church, and they're redacting it. This is a 911 call. Okay, we'll cut back to it. Law and Crime has a bunch of it, so let me see. We have this one. Before we go to Law and Crime, hold on, let me. We'll watch the Law and Crime on it, and I'll share my documents with you, but I'll go back through it and put a video out, and we'll talk about it, or I'll put it out and we can go over it tomorrow. So this is the communications, and Okay, so August 4th of 2025, they went out for a person shot. Starting on March 24th of 2021, there was a self-deletion threat. On July 8th of 2022, there was a disturbance in the household. On March 21st of 2024, there was one sick or down. On April 5th of 2024, one sick or down. On April 27th of 2025, they followed up on that. Hold on just a minute. Hold on just a minute, y'all. Hey, sorry, y'all. I got my littles. There was a minute. I apologize about that. I had to. Okay. On August 27th, they followed up on that investigation. And then obviously of August 4th of 2025, which was just not that long ago, there was two persons shot that they responded to at the address. So what this is showing me is that there has been a history of some type of disturbances and things like that. It sounds like possibly the young man was not mentally well. Okay, I'm gonna I'm gonna look into it. Thank you. And then again, I guess we've got two pictures of his mugshot. And I mean, again, going back, I think that he might have a history of some type of mental help needed. Okay, this is a different incident report. So it says on the 4th day of August at 12 a.m., the defendant did do the following. And then it says on August 12th of 2025 at 9, the Clay County Grand Jury was impaneled and sworn to inquire and true presentment make in and for the body of the County of Clay upon their oaths and present and charge that Trevor Lee committed 2 counts of homicide in the first degree, premeditated. All counts received no bond. So this was just what a couple of days ago, the charges got changed to premeditated first degree homicide. The defendant was served this indictment while being processed at the Orange Park substation, reference to the case number. And then all of that was redacted so far. I wonder what made them change it to premeditated. All right. So let's go over to the law and crime breakdown of this case. And then after that, when we go for the day, I'll work on getting those out for you guys, those audios, so you can hear them better.
Yes, sir. Go ahead. I'll listen to you.
A 14-year-old boy faces new charges in the murders of his parents after the sheriff said he called 911 and confessed. I look at the new information we're learning about the case of Trevor Lee out of Florida.
Okay. Hold on.
Welcome to Crime Fix. I'm Anjanette Levy. A 14-year-old boy should be focused on homework. summer break, and in Trevor Lee's case, football. But instead, this teenager, he's in jail facing murder charges for the deaths of his parents. I first told you about Trevor Lee last week when he shockingly called 911 from a church and told a 911 call taker that he shot his parents, according to the sheriff in Clay County, Florida, just outside of Jacksonville. At that time, Trevor was booked into the jail on second-degree murder charges. But now the grand jury has returned an indictment, and those charges have been bumped up to first-degree murder. That's the most serious charge you can face in the state of Florida. The indictment states that the murders of Dave Lee and Brandy Smith were premeditated by Trevor. If Trevor is convicted, he could spend the rest of his life behind bars. Though under Florida law, his case must be reviewed after 25 years because of his age. Now, Dave Ehrenberg, the former state attorney for Palm Beach County in Florida, he's going to join me here soon to talk about this turn of events.
So I wonder what made them change it from second-degree homicide to first-degree homicide.
This case, it really makes you wonder what was going on here. We've seen children charged as adults before in Florida, but the information available so far in this case has proved that this case is really mind-boggling. A child murdering both of his parents over what? Possibly an argument? An incident report says that Clay County deputies found Dave Lee and Brandy Smith with multiple gunshot wounds in their bedroom. Now, we recently obtained copies of CAD records and notes from Clay County's Sheriff's Office that are shedding some light on 5 other calls to the Lee family home since.
So that was what we just went over. JoJo said, I guess he thought he could get sanctuary at the church. I don't know if it's some kind of mental thing, because I could hear the call and he was asking the people to pray for him, and he needed to pray and all of that. So I don't know what he thought exactly. Hey, Love to Hunt, good to see you. Yeah, there is really bad coping skills in kids nowadays.
2021. The first call was on March 24th, 2021 for a threat that someone might be trying to hurt themselves. The report shows the duration of the call was short, just about 2.5 minutes, but the response time took a while. The notes indicate the first deputy arrived at 8:59 p.m. Officers remained on scene for 49 minutes. Then in 2022, there was a call for a disturbance. The notes state that on July 8th at 5:26 a.m., a woman called 911 to report that a male was holding her against her will. But there are some redactions, so we don't know whether the male was Dave or Trevor. When the deputies arrived at the home less than 3 minutes later, after the call was placed, the female told law enforcement she did not want them there and to leave because she was heading out. The notes indicate the male was allegedly withholding her military ID because he didn't want her going to the naval base since he was, quote, scared that he will be exposed and that she is going to embarrass both of us. Now, we don't know.
I think that would have been the dad, maybe.
What that male meant by being exposed. We could assume this was Dave Lee saying this. In that instance, the deputy was at the home for just 15 minutes. On March 21st, 2024, deputies were called to the house twice for a sick person. The caller said a female was having stomach pain and difficulty breathing. Timestamps on the report show the call lasted less than a minute and the event was canceled. The second call came 2 weeks later on April 5th around 11 a.m.
What the crap?
The caller was heard saying, hello, and oh my God, before the call was disconnected. Less than a minute later, dispatch called back, and the caller said a male was having nonstop stomach and chest pains, with pain radiating into both of his arms. The report indicated the call lasted for less than 2 minutes. This time, again, no deputy was dispatched to the residence. According to the notes, a female was complaining about stomach pain. Then on April 27th of this year, it appears a deputy initiated a follow-up investigation. Then came the call from Trevor Lee's sister, reporting the shooting early in the morning on August 4th.
Are you there with him? Send help. No, I'm all the way in California. Please, I need you to send help. What makes you? I don't know. I don't know where he's at. I have no idea where he's at. But please, hurry up.
As a breaking news reporter, I live.
This is interesting. I'm going to pull those records too, because if she has it, I should be able to get it. Sandra said maybe that's why the kid did what he did, domestic violence in the house, and nothing was ever done, and the kid just lost it emotionally and did what he did. I agree. Yeah, and then that crossed my mind too, Tom. Maybe did he try to poison them?
In the arrest.
You know, what's interesting is after he shot his parents, he walked over a mile, about a mile and a half, to a church where, and we believe during that time that he was walking to the church is when he called her, and then when he got to the church is when he called our 911 communication center.
Do we have an idea? I mean, that's, you know, another kind of strange thing about this. Do we know why he decided to walk to the church? I mean, I can kind of connect a dot and think that he called his sister to tell her what he did, and she likely told him to call law enforcement. That's where I'm going in my head with that. But why walk to the church?
Well, where his house is in relation to the church, even though it was, you know, probably close to a mile and a half walked, it was a pretty direct line. This church sits up on a major road and is easily discernible as you're walking. And you know, I'm thinking like you, that his sister just encouraged him to call 911. And he probably felt that, you know, walking up to the church and waiting for deputies to arrive was probably the safest place for him to do that.
So he walks to the church and he calls 911. Your call takers, or the 911 center call takers, I'm assuming, you know, they're dispatching, they're trying to get information from him. They're talking to him. What can we glean from this whole thing about why this unfolded the way that it did?
You know, interestingly enough, we've had quite a few swatting calls in our community over the past couple of years. So initially when the call came in, there was some concern with our communication center that this was going to be another swatting call.
So is that why, I mean, I'm wondering if she's saying that because the response time, because these calls are like 20 minutes, 30 minutes. I don't know. JoJo said, I would want to know if he was on any type of meds for one of those alphabet disorders they say our kids have nowadays. I believe some are real, but not all, and that they are medicating our kids. I don't know. Maybe Speedle. Oh my goodness. Card just gifted 10 memberships. Thank you so much for that. I really appreciate that. Thank you so very much. Let me see if I can see. Those went to Spooky Bitch 1331, Lens, Shane Nowlin, Cat Lissa, B Frank, Tried and True, Jen T-Rex, and Winged Matchbox, and also SW Southwest Florida, Mama 4, Kimberly K. If you guys were gifted from Cara and you are aware you were gifted, please tell Cara thank you, and I will grab the crazy train to pick y'all up on the way to Speculation Station. Thank you, Cara. Thank you so very much, sweetheart. I really appreciate that. Yay. That was sweet. Give me one of them their memberships. I wish you could. I wish it would let us pick what who got it so we can make sure that people that were in chat got the memberships. Oh, Spooky Bitch said thank you. Thank you for saying thank you, Spooky Bitch. I know, it's sad Ozzy's deceased.
So our communication center kept him on the line for quite a while as deputies responded to the house and surrounded the house and then attempted to make contact with the occupants inside the house. And based upon the information that our communication center was being given, the deputies made the determination to go ahead and make entry into the home to do what we call a protective sweep, where the deputies found the two deceased parents. And then our comm center, our dispatcher did a fantastic job keeping him on the phone and talking to him. And within just a couple of minutes, we were able to put eyes on him at the church. You know, and at this point, we don't know if he was still armed. So the deputy that had eyes on him waited for a couple of backup deputies to get there, and then they came up with a plan and took him into custody. He came into custody peacefully. He did not push back at all. He was in fact extremely cooperative with the deputies who took him into custody at the scene at the church, and then also with the detectives later on in the evening who were interviewing him.
Now, just to be clear, Trevor
That's interesting.
Lee's sister in California called 911, but he also called 911 from the church. So Sheriff Cook said that Trevor confessed to shooting both of his parents with his mom's gun and then waited a short time, called his sister, and then walked to the church. His sister actually called 911 before he did.
Honestly, I'm in the military. I don't know what goes on, but they just had a good day. They went to the movies, bro. They went to the movies.
Now, the older sister told the 911 call taker that they had a good day and had gone to the movies. Then Trevor Lee called 911 from the Cross Point Church early Monday morning. And a lot of these calls, they're redacted. Because in Florida, if a person makes admissions to a crime, they're redacted from the public record until the case concludes.
911, how can I help you?
Hello, I'm by the road. I threw my backpack away from me. I'm stripped. I'm waiting for the police.
What do you mean you're
I have
stripped?
nothing in my pocket. I emptied my pockets and everything. There's nothing in my pockets. And
That goes to what you were saying earlier, Speedle. Oh, yeah, I like your name too.
I'm not like on the sidewalk. I'm like in the middle part.
You're going to be in the parking lot?
No, like in the middle part.
The middle part of what? Of the church?
I'm gonna pray first. I need to pray.
You need to pray?
Yes, ma'am.
Okay. Before you start praying, tell me exactly where you're at.
If you're driving towards the church, like I'm right out in front of the church, there's a big cross. Do you pray?
Yes, sir. Go ahead. I'll listen to you.
Well, I was going to ask if you could pray for me, ma'am. Right now.
I'll definitely be praying for you, son. Okay, we've asked them not to point guns at you. Okay, they're going to be approaching you any minute.
So to talk about this new
That makes my heart hurt. I wonder, I mean, because it definitely sounded like it was, when we go back to where the woman was being held against her will, it sounds like it was the father holding her against her will, saying that she was going to expose him if she went to work. And I'm wondering if this child has seen a lot of things, and I don't know, he found solace in the church. That part where he's like, I'm going to pray and I need you to pray for me or pray with me. It kind of breaks my heart. And I don't understand. I'm trying to kind of place if it's like a mental thing, as in, like if you think about the movie Carrie, how her mother would like shut her in the room with the Bible and make her pray. Like, not necessarily that was going on, but sometimes when there's like a mental thing going on, it has to do with religion and things like that. So I'm wondering if he has something going on like that, and that's what the praying thing's about, or if he found comfort and solace in God and protection when his parents were fighting or something. And then the sister mentions them having a good day today. So that tells me they normally, or more often than not, had bad days. I'm getting a lot from this, but I'm still confused.
Indictment of 14-year-old Trevor Lee. This is still kind of boggling my mind. I want to bring in Dave Ehrenberg. He was the state attorney in Palm Beach County for many years, and he's had to make decisions about charging teenagers as adults. So
we could listen to a little bit of this. I don't usually listen to where they bring the people in. Thank you for that. My toe is better, but it still hurts. I didn't think about putting tea tree oil on it though. I use doTERRA oils, and I actually do have tea tree, so I'm going to put some of that on it. I don't have arnica. I've been trying to grow arnica for years now, and I can't ever get it to grow. What did Speedle say? I'm opted in now. Awesome. I'm glad that you're opted in.
Dave, thanks for coming back on to discuss this. When we last talked about this case, Trevor Lee was charged with second-degree murder. Now they've bumped that up to first-degree murder, and you didn't think that would happen. So what's your response to that?
It means that investigators and prosecutors must have determined that there was premeditation here, Anjanette. And you don't need a lot of premeditation. There's an old saying, all you need to do in the real world, if you're thinking about killing an ant, is to think about it just for a couple seconds and then step on the ant. That would be enough for premeditation. So if they had a fight and then Trevor Lee grabbed or had to search for the parent's gun and then killed his parents, yeah, that would be enough premeditation. I was just surprised because he's a juvenile, 14 years old, he's not eligible for the death penalty. So when you normally charge someone with first-degree murder, you get a grand jury indictment, it's a capital crime, and then that person is eligible for the ultimate punishment. But here he's not. And so he's eligible for life in prison, which he could also get in a second-degree murder case. So that's why I was a little surprised by it. But at the same time, in Florida, if you seek a...
So basically, the highest they can go is life in prison, and because of his age, and it would be life in prison whether it was second-degree homicide or first-degree premeditated homicide because of his age. And so he's saying he was a little surprised that they bumped it up to homicide. Premeditated first-degree homicide. This is out of Florida. That's how I was able to get the records back so quick. Tom, I know I'm real concerned about him, and I want to know more. Premeditated, legally speaking, is so tricky. It could be 1 second before the incident. Yep.
grand jury indictment for a juvenile, which apparently is what happened here, then the court is limited and cannot impose juvenile sanctions. The court must impose adult sanctions. And so that's why perhaps the prosecutors did this.
To impose adult sanctions on a 14-year-old? I mean, like, did he have a freaking manifesto? Lord, what's going on?
And that's what's so interesting to me, because this is a juvenile. And so he is not eligible for the death penalty. And it sounds like, you know, a lot of what we're getting, the records from the sheriff's office, is a lot of it's redacted, and they're not releasing the body camera footage, which in Florida to me is like kind of wild, because in Florida, I feel like everything goes for the most part. You know, the Sunshine State has really good sunshine laws, and usually you can get a hold of everything, and they're not releasing the body camera footage right now. Citing some Florida statutes. So that was surprising to me. But you've got a kid, a 14-year-old, who is now charged with the premeditated murder of his mom and dad.
If we pause this picture right here, his mom and dad, she looks, just looking at her face, like he's smiling in the background, and his eyes are smiling as well. Her eyes, it's not, it doesn't, it looks like a forced smile, and her eyes are scared. It doesn't look natural to me. And here I see a finger under her arm. I think he's like holding her arm or something. She looks afraid almost. And he looks happy but conniving. She looks forced to be happy and afraid to me. Do you guys see that? Jojo said, I am in data science and went to a conference regarding connecting first responders with data science engineers to help alleviate issues. I heard the stats, but never heard firsthand account of it. Yeah, afraid or sad, right. It's suspicious. It is. Prefer the death penalty versus being in prison for life. That would be a hard one, because when it came to actually the death penalty being carried out, I think I'd be very afraid. He does.
And then he walks to a church and calls 911. And we don't know what he said, because of the laws in Florida, it's redacted what he actually said, the admission, and says, I killed my parents. And he's like praying with a 911 call taker. I mean, I'm just kind of like, what is going on here?
Well, they've got the confession, And I don't think that is going to be an issue at trial, whether he's the one who actually did it. Perhaps they'll try to go to state of mind, and perhaps they'll try and negotiate this into some settlement in advance of trial. But there are some exceptions to the public records rules for ongoing and current investigations.
I mean, again, I think that the issue there is going to be that he's a juvenile, so they're not going to release a lot about it. She looks sad to me too, right? Yeah. Well, I'm going to end it here for today so that I can work on those videos and try to get that stuff out for you guys so we can have a new video to listen to, and I can bump that audio, and we can try to break it down a little bit better than we have today. But I think we covered quite a bit. I mentioned that because Abella said that she called 911 once and got a busy signal, and it surprised me even after seeing the stats in black and white. Oh, really? Hey, Sam. Okay, I'm going to end it here for today, but yeah, feel free to go back and start from the beginning. We covered quite a bit today, actually. And tomorrow, I'm sure we'll cover quite a bit as well. So I'm going to go so that I can, go ahead and start getting these files together and try to get a video made and out before tomorrow, because it takes a while. Thank you guys for being here. Thank you for the support. You guys are amazing, and I love you guys very much. I love the time we get to spend together every day. If you guys weren't here, I would be talking to myself, and I appreciate y'all's thoughts, opinions, and speculations, and you sharing them with me. If nobody has told you, you are enough, you are important, you are special, and you are loved. And I'll see y'all tomorrow. Thank you. Bye.